All right, good morning, everyone. It's July 8th, 2021, and this is the Fair Political Practices Commission Law and Policy Committee meeting. Mr. Vo, would you please call the roll?
Commissioner Baker?
Here.
Chair Matich?
Here. We'll proceed to item number 1. This is public comment for items not on today's agenda. Do we have any public comment? Hearing and seeing none, we'll proceed to item number 2. Approval of the June 10th, 2021 meeting minutes. Commissioner Baker, any edits or comments on the meeting minutes?
No edits or comments. Move to approve.
Second, Mr. Vo.
Commissioner Baker?
Aye.
Chair Matich?
Aye. Moving right along to item number 3, this is our legislative update, and we will welcome to the table our legislative counsel, Ms. Nakano. Good morning.
Good morning. Okay, I'll provide updates today on the priority commission bills and on other commission-related bills that the committee may wish to discuss and recommend a position on to the full commission next week. First, AB 378, the bill that would make language throughout several areas of code, including in the Political Reform Act, gender neutral, passed in both houses and was enrolled and presented to the governor on June 29th. AB 1367, relating to egregious personal use of campaign funds, is set for hearing in the Senate Elections Committee on July 12th. This bill, as you remember, previously included a proposal relating to campaign bank accounts. After discussions with stakeholders to identify concerns and questions, staff came up with an alternative proposal that would instead prohibit commingling of contributions with any funds that are not campaign funds, which would still accomplish the original goal of allowing for better tracking and tracing of campaign funds. And the proposal would additionally add a long-arm statute to allow the Commission to reach persons and records outside of the state, including out-of-state bank accounts used for campaign funds. After discussing this possible alternative with the author staff as well as the committee staff, a decision was reached to not add this new proposal to the bill this year, given where we are in the legislative year, and particularly because the alternative proposal, while it would accomplish a very similar goal as the original proposal, it gets to that goal in a very different way. So the committee wished to have more time to consider and develop the details before we moved forward. So AB 1367 will be continuing on with only the egregious personal use proposal. AB 1590, the Assembly Elections Committee bill that includes the committee annual fee proposal, passed in the Senate Elections Committee 5-0 on June 29th. SB 686, the Commission's sponsored bill on LLC disclosure, was amended on June 23rd to adjust the thresholds for inclusion on the LLC's statement of members and to delete the portion of the bill codifying recent regulations to the LLCs, or to LLCs. The thresholds were changed from $1,000 in cumulative capital contributions to $10,000 in cumulative capital contributions, and the look-back period was shortened from 2 calendar years to 12 months before the LLC qualified as a committee or committee sponsor. The California Chamber of Commerce formally removed its opposition to the bill after these amendments, and the bill passed in the Assembly Elections Committee 6-1 with Assembly Member Sayarto voting no. Because the bill was amended substantively, the Commission may wish to vote next week on whether to continue to support and sponsor the bill. This committee may wish to vote to make a recommendation to the Commission, so I'd be happy to take any questions or facilitate any discussion.
Thank you. Commissioner Baker, any questions for Ms. Nakano?
Not on those matters. I think you answered it because I know we're a sponsor of the bill, but it has changed. I like those amendments. I know we've talked about them in the past. I think it is less likely to capture, smaller business and very small actors with a potential big landmine, and it really focuses on the folks that should receive it. And I would be inclined to recommend to the full commission that they do support the bill in its current form.
I agree. So why don't we?
Do we need a motion for that? Yeah.
I take it that you have.
That's my motion.
That the committee recommend that the full commission continue sponsoring SB 686. I would second that. So, Mr. Vo?
Commissioner Baker?
Aye.
Chair Matich?
Aye.
Motion passes.
Did you have anything additional? additional for, all right, Ms. Takano, please continue.
Okay, thank you. There are 3 other commission-related bills that the commission may also decide to take a position on next week, and those are AB 775. I think it's erroneously written in the report as SB, but it's AB 775, recently amended to delete the prior language in the bill and insert new language relating to recurring contributions. SB 459, relating to lobbying reports and issue lobbying advertisements, and SB 752, relating to campaign advertisement disclosures. I'll go through all of those in a little more detail. I'll start with AB 775. This bill responds to the practice of soliciting automatic recurring contributions, often initiated through the use of a pre-checked box or through settings that otherwise require an active opt-out. And General Counsel Dave Bainbridge and Counsel in the Legal Division Kevin Cornwall prepared a memo attached to today's agenda that includes background on the issue as well as discussion of this bill, and I will work that memo into today's discussion. So for some additional background, many news outlets in recent months have reported on the use of pre-checked boxes for collecting recurring campaign contributions. What this often looks like in practice is a person will go online to make a single contribution, and the box for making the contribution recurring on a regular basis is pre-checked. So active action is required to prevent a single donation from becoming recurring. In some cases, a person won't even realize they've signed up for 4 recurring contributions, and news outlets have reported that it can be very difficult to stop those automatic donations. The FEC recommended that Congress prohibit the practice at the federal level by requiring affirmative consent for recurring contributions, also requiring disclosure of additional information to donors, and to immediately cancel the recurring contributions upon request. Since that recommendation, 2 bills have been introduced at the federal level addressing the topic. Last month in this state, AB 775 was amended to delete its previous contents and insert new language to address the same issue. The bill would prohibit a candidate or committee from soliciting or accepting a recurring contribution unless they receive affirmative consent. The bill also requires those candidates or committees to provide a receipt within 3 days of each contribution, disclosing all terms of the recurring contributions, and the bill requires candidates and committees to provide all necessary information needed to cancel the recurring contributions and to immediately cancel the recurring contributions upon the request of the contributor. This language substantially mirrors the language in the Federal Senate Bill 1786. The memo from Council recommends 2 suggested amendments. The first would add additional penalties if the candidate or committee fails to return contributions to the donor within a specified time frame if those contributions were collected without affirmative consent. This would help protect prospective victims and encourage reimbursement of those improperly collected contributions. The second suggested amendment asks for clarity on whether a violation occurs only at the time of the initial payment, or at the time the initial payment is collected without affirmative consent for the future recurring contributions, or if a violation occurs each time a payment is collected where the payer did not give affirmative consent. So Council's suggestion is to add clarification here as to potential liability, whether it's one time or each time the recurring contribution is collected. And I'll ask now if the committee would like to discuss the bill and or the Council's suggested amendments.
Thank you, Ms. Takano. Quick question for you on the last point you made with respect to staff's recommended amendment. This is clarifying whether the failure to obtain affirmative consent is a one-time violation or recurring. It strikes me that that's very similar when a committee may not timely get the occupation and employer information for a contribution. So what's the state of the law there? Is that considered a single violation or is that recurring?
I think I'd defer to Mr. Bainbridge.
So the scenario we're talking about is when someone doesn't provide the occupation and employer on multiple reports for the same contribution? Is that the...
Right. It strikes me that it's analogous to the situation here where you haven't obtained affirmative consent. So I'm just trying to get a sense under existing law, how do we treat this type of thing? Do we consider it multiple violations, or do we consider it one violation?
Yeah, each instance, each report can trigger its own violation. So each time they failure to properly report it on a report is going to be a separate violation.
And is that provided for in the statute, or is that how we enforce it?
I don't know the answer to that off the top of my head if it explicitly says it. I think it's implied for sure from the way the statute is written that the report needs to be full and accurate. So each time a report isn't complete or accurate, it doesn't contain the information, it's going to be its own violation because of the fact that what has to be on it's a separate report, so then it becomes a separate violation each time. I think this one's a little bit different in that it's not a reporting instance, it's a continued act of having these contributions. I think your point is a good one, which is it may already be the fact under the Act that this is going to be a separate violation each time, and I think it could definitely be read that way. Our point was just we could clarify that and I think provide a little more incentive for people not to just do it and do it again and do it again and do it again if they know they're going to be subject to liability each time.
Yeah, no, and I appreciate that. I think it's a good point for staff to raise to us. The other question I had is, enforcement oftentimes consolidates under one count multiple violations of the Act for purposes of settlement agreements. And so I think one perspective I have is I wouldn't want to inadvertently, through clarifying this, reduce the discretion that enforcement has with how they charge things. And so I don't know if staff give any thought to, if we did propose a statutory change here to clarify this, are we inadvertently reducing enforcement's discretion here?
I hadn't thought of it that way. I'd thought of it kind of in the other way, which is this ensures that they maintain the discretion to make this decision of whether they feel that if, say, a committee for 4 months has this recurring contribution that results in a violation, they then have the option whether to charge it as 4 separate counts or to combine them all into a single count, depending on, all the mitigating and aggravating factors that they typically consider.
All right. Thank you. That's helpful. The other question I had is affirmative consent. The statute, it doesn't seem like it's overly prescriptive in defining what that consent looks like. And so my question is, do we feel like under the existing bill that we would have sufficient discretion to define what affirmative consent needs to be through our regulatory powers?
Yeah, I think so. I think that's a term that we could definitely define of what would constitute affirmative consent, and it could be helpful depending on how this plays out to provide examples of what committees should be doing in order to obtain affirmative consent.
Okay. All right. Thank you. Those are all my questions for now. Commissioner Baker?
I have some as well, all good questions. I second those. On the last point, there is some precedent in other statutes that the legislature has passed on the issue of when you're basically opted in automatically or opted out. The privacy laws are off. The raging debate occurred in the legislature on that issue. So there may be, to the question of affirmative consent, language to borrow or examples that we can do that. So I encourage the team to take a look at that and encourage the authors to look at some of the opt-in, opt-out language so we maybe aren't reinventing a wheel. And with respect to the recurring contributions and when the violation occurs, my feedback is to also be looking at other areas, not just the employer is one good example because it's not ministerial, but it's something that can happen almost in a serial. Once they make the mistake, they can repeat it over and over again. If there are other areas within our regime of campaign disclosures and finance that are instructive on that we may look for those. None are coming to mind right away for this commissioner, but that is a suggestion that I have. A couple other points about the provisions of the legislation. On the question of, well, I think I want to go to a little bit back in the notes. The bill's language has a candidate or committee shall not solicit or accept. And the solicit popped out in my mind because I wonder why you can't solicit. You can ask them, do you want to do a recurring contribution. It's accept or require. I'm not trying to rewrite the bill, but I just encourage us to take a look at that and see if that we don't accidentally support prohibiting the solicitation of it. It's very possible that campaigns should be able to say, hey, I'd like you to do this. What we're going after is the practice of automatically opting them in and making it very difficult and almost impossible to opt out or get refunds. And so that was language that popped out in my mind. You may highlight that with the authors as you visit with them. Also may look at the manner in which the refund has to get to them by a certain amount of time. If they're going to cover that in the legislation, I'm imagining the scenario from the first-time candidate who they had somebody give affirmative consent, but then they got mad at the candidate because the candidate took a position or endorsed somebody that the donor doesn't like, and the possibility that the donor will start to claim that they didn't have affirmative consent, then I'm not getting my refund fast enough. Sometimes people have an axe to grind when that happens. And so I would just raise that conversation, again, with the authors and ourselves internally, because we don't want to create a situation where either it's really easy to violate it when you're a well-intentioned person and you're opening yourself up to potential abuse, or what people outside of your control can do when they change their mind and don't want it anymore. So that would be a point as well. Additional point on the issue of receipt. The legislation, the draft that I saw, doesn't really talk about what the receipt would look like. We may not want to have them, we might not want to overly prescribe what a receipt is going to be. I think we're envisioning something that's happening through online contributions, but these solicitations could also happen at an event where you have a good old-fashioned remit envelope, and that takes some time for campaigns to process. They have a responsibility to do it in a timely way so that they can do their disclosure requirements. And then there may be more time on the receiving end before somebody correctly processes if it's a recurring contribution request, opt in or opt out. So I'm just encouraging them to look at the scenarios outside of the digital online contribution to make sure we are, again, not setting up a landmine that we're not intending to. Well, we never intend to set up landmines, but we're not setting one up, and that we're nimble in that area. Those were my initial feedback. A couple others I'll throw out there because I had a lot of thoughts on this one. I don't know if we want to have a safe harbor, a situation where a mistake will be made and you can have incredible liability from it if this becomes a recurring contribution that happens over time and you're a campaign that has many, many transactions. People do make mistakes. I don't know if the safe harbor, if we want one, or if it's just that, if you refunded it within X amount of time, maybe you won't get an immediate penalty, or if we're just leaving that to enforcement discretion. I encourage that to be part of the conversation. I haven't fully digested what I think on it yet, but that popped to mind as well. And the final one is, and I think this may be coming up at a subsequent hearing for us, is what our authority is to prohibit this method of campaign contributions that really are inherently deceptive and predatory. This isn't like you're buying a shirt online and they automatically opt you in for newsletters from the shirt store. This is someone taking your money and making it very difficult for you to get it back. And legislation, I presumably this is a 2/3 vote, I would think, because this is an amendment to the Act. And I don't know if it has to separately have an urgency clause to become effective upon signage, or if it would have to wait until January 1st of the following year. But whatever path is going to be faster, and also correct, if our regulatory path could end up being faster. Some of these legislators are limited to a certain number of bills this year, and we're going into an election year in the midterms, and this is a practice that both parties have been doing. And so I'm curious what could potentially be the faster path. That's probably a question for Mr. Bainbridge to remind me of. If we wanted to pursue this from a regulatory matter, if it isn't signed into law and becomes effective immediately, could our regulatory side do it if we have the ability to prohibit it?
Generally, the process for regulations takes, once the language is drafted, at least 45 days, usually more like 60 if we go along our normal path of presenting it to the commission prior to noticing it. So potentially could be quicker if it doesn't have, could be faster than January 1st. I don't think we have clear regulatory authority to do what this bill does, which is prohibit these payments in the way that it does. I think this is a much more direct route. We did explore the regulatory authority we would have here, and we were more comfortable with sort of some sort of reporting requirement as opposed to a prohibition. So I think to get the prohibition, the legislation, even if it takes a little longer, is definitely the better route to go.
Okay, so we don't, and I'm maybe getting a preview ahead of time, but we don't have authority at this time to prohibit in the way that the bill is attempting to do.
That's correct.
Okay. Well, I hope it has bipartisan support. I'll say that as one person, and I hope that it can move expeditiously because this is deceptive and predatory. And I hope these additional points are helpful as they're looking at the bill to get it right and hopefully not overly complicate it. I hope they will also look at what immediately cancel the recurring contribution means. That's pretty, what are they going to do? What's considered immediately? What's considered delivery of the receipt? Are you providing a receipt by dropping it in the mail? Are you providing it once you send it? I'm sure there are things in the statute that are presumptions and that they'll look at those. But those would be things to look at. So thank you.
All excellent points, Commissioner Baker. I think the one thing that strikes me here is we began this process in light of the fact that this clearly, as you said, it's predatory. This is a problem. We're seeing this, and something needs to be done. I think at this point, the legislature is in the best position to take the first crack at it. And I would just say that I agree there are a number of terms in the bill that don't, on their face, admit of a very specific definition. I think as long as we are satisfied that we have continuing regulatory authority to define those terms and be more flexible as experience dictates, then I think my preference would be to allow the legislature to craft a bill that broadly seeks to accomplish the objective we're trying to do, and then allow us through the regulatory process to fill in the gaps as administrative agencies tend to do, in part because I think there are going to be circumstances in which a receipt in one context may not look the same or be deliverable in the same way as in another context. I'm thinking electronic versus more traditional forms. And I think doing that through regulation and being a little bit more nimble and flexible there, that may be beneficial not only to ourselves, to enforcement, but also to the stakeholders.
Great point. Are we, is this a potential support if amended? Excuse me, are we finding that we want to wait until, welcome your thoughts, wait until it goes along the process? What are your thoughts on that?
Well, you were anticipating my next thought, because my next question actually was for Ms. Nakano, is, what's the timeline like on this? When's this going to be heard? And what are the expectations of feedback from our agency on the bill?
I checked in with the committee on the possibility of making the amendments if the commission decides to support them. And they said it is a possibility. The author is open to considering them. He wanted to see what the commission decides and kind of what the discussion was. But there is a possibility that amendments can be made.
In timeline, is there a hearing set on this bill already?
There is, I believe it will occur before the commission meeting, but the author has indicated that there will still be opportunity to amend afterwards if we keep the committees updated and everybody's aware of the changes that they're considering.
All right. Well, I think, for myself, I think that the broad strokes of this bill are correct, and I think it's a sensible approach, certainly better than the status quo. And so I'm inclined to support the bill and express at least our committee's support for the bill, as well as our support for staff to explore with the author the areas of potential amendments that are identified in the staff memo, as well as some of the areas that Commissioner Baker mentioned during her comments as well. So I think I'm broadly supportive of this effort, and I think we have some additional ideas that if you would go back to the author and explore those as possible amendments, I think that makes sense. What do you think?
Agreed, I really do, and give them good positive encouragement, and hopefully we can act quickly. So, and I know that we're in the, it's, you know, the legislative season is pretty ripe. This is a get and amend, so I guess it can come back over to the Assembly. I should remember this process. If it has to go through committee again very rapidly, since it's substantially so different before it hits the floor. But we'll want to just, the pace will be so quickly, we'll be watching those amendments carefully. I hope they're not late hour. Thanks.
Thank you.
Thank you, Ms. Nakano. Thank you, Commissioner Baker. I think you have more for us, Ms. Nakano.
Yes, does the committee wish to vote on whether to recommend anything to the commission next week for this bill? Or would you like to wait a little bit and see what happens in the committee?
Here's the thing, is I think I'm reluctant to recommend, to today make that recommendation, because what I thought you said is that this is going to be heard and there may be potential amendments before the commission meeting next week. So I prefer to, when it comes before the commission, to have what is actually in print come before the commission before we take a position.
Understood. Thank you.
Thank you.
Okay, I'll move on now to SB 459. This is on lobbying reports and issue lobbying advertisements. The bill was recently amended on July 6th with amendments suggested by the Assembly Elections Committee, and the bill does three main things. First, the bill adds to the information that must be reported by lobbyist employers, $5,000 filers, and lobbying firms in their quarterly periodic reports. More specifically, the bill requires disclosure of the bills or administrative actions on which there was direct communication with certain individuals for the purpose of influencing legislative or administrative action. The bill also requires disclosure of the client position publicly taken and disclosure of any issue lobbying advertisements made during the reporting period. Second, the bill would require two new reports. A lobbyist employer or $5,000 filer would be required to file a report within 24 hours of retaining a lobbying firm to influence legislative action during the 60 days before the end of the legislative year. And second, the bill would require a lobbyist employer or $5,000 filer to file a supplemental report within 24 hours of engaging in direct communication with an elected state official, agency official, or legislative official on behalf of a client for the purpose of influencing legislative action. Third, the bill would impose new regulations on what it calls issue lobbying advertisements. The bill defines this term, and generally these are public communications paid for by a lobbyist employer that solicits or urges a particular result with regard to a legislative or administrative action. The bill requires on-ad disclosure of who paid for the ad. It requires a copy of the ad to be provided to certain officials if the official was clearly identified on the ad, and it requires a report to be filed to the SOS within 72 hours of spending $5,000 or more on issue ads in a calendar quarter. The bill also has a delayed operative date and would go into effect 1 year after the CalAccess replacement system is certified, or January 1st, 2023, whichever is later. The bill was heard in the Assembly Elections Committee last month and passed out of the committee 6-0 with Assembly Member Sayarto not voting. California Common Cause is sponsoring the bill, and there are 5 other organizations listed in support in the committee analysis, including the California Clean Money Campaign and the League of Women Voters of California. The bill also has several organizations listed in opposition, including the Institute of Governmental Advocates, the California Political Attorneys Association, and the California Federation of Teachers. Some of the opposition was downgraded after the committee's amendments, but some groups voiced continued opposition in the committee hearing. IGA highlighted a few remaining concerns, including a concern about the burden of 24-hour reporting on sole proprietors, the additional level of complexity added by increased reporting, as well as First Amendment concerns with the issue lobbying advertisement piece. And I'd be happy to take any questions on SB 459.
Thank you, Ms. Nakano. I did have kind of a technical question, but I think I understood you to just say a moment ago that the disclaimer on lobbying advertisements would be required when it was paid for by a lobbyist employer?
Yes.
What if a lobbyist paid for it themselves? Not a lobbyist employer, but the lobbyists themselves.
It only identifies lobbyist employers and $5,000 filers as those who would have to disclose on the ad.
Okay. Is there a reason why it is limited to just advertisements that are paid by lobbyist employers?
That I don't know.
Okay. Well, like I said, just kind of a technical question. Commissioner Baker, do you have questions?
I do, thank you. You mentioned that some groups have, I don't know if you didn't say they removed their opposition, but they had opposition to a prior version. And I'm just looking at the committee analysis. The Political Attorneys Association and the Professional Political Treasurers Association had opposition in the past. Do you know what were, you mentioned, I think, IGAs, but do you know what their main points were? I can try to predict, but I'm kind of curious what they articulated.
I don't recall that they called in, and if they did, I missed it. But I am in the process of getting their opposition letters, although it will be for the prior version of the bill, so it may be only so helpful. But I might be able to determine, based on the amendments, which concerns might still remain, and report on that next week.
Thank you.
Do we have a sense, Ms. Nakano, whether there are potential constitutional problems with the issue, what I call issue advertisements, I think they call them lobbyist advertisements, the regulation of those types of communications? Have we looked at that? That is my first question. And secondly, if there is, I will just characterize it, a significant risk that that could be invalidated by the courts, whether our fiscal analysis on this bill includes that amount. Because obviously, you know, we don't want to get stuck paying a judgment on this.
Generally, this is political speech, so the bar for the scrutiny is fairly high. There needs to be a strong government interest, and the solution has to be more tailored to that interest. I don't have the exact standard in front of me. And there's a higher level of scrutiny required generally for political speech. The fiscal, we have not included the potential litigation or the potential expenses if this is challenged, but staff is looking into what that would cost if the bill was challenged. There's a second question. What was it?
No, I think you've,
I was
asking you, is there a constitutional question here about whether this particular portion of the bill could be invalidated by the courts? So that was the first part of the question. The second part was the fiscal impact and whether that's been worked in. I hear you to say political speech is subject to a heightened standard, and so there's a possibility that this could be invalidated by the courts, potentially. And that the fiscal analysis will be updated at some point to include the potential risk to our agency for a judgment in the event that somebody did successfully invalidate that portion of the bill.
That's right. Yes, correct. Thank you for the better summary. Can
I just ask a question on that one? And we would be the agency that would have to deal with that. So they could someone who would be challenging it could challenge it as soon as it's presumably signed by the governor, but it's going on our tab. It's not the Department of, well, the tab is the taxpayer's tab, of course, but the DOJ, or they may represent us, but it would come out of our budget, which again is taxpayer money wherever it's coming from, but yeah.
That's
Is that right?
That's my understanding as well, and so that's why I just think it's important that we include that as part of the fiscal summary if we believe there's a significant risk of that portion being invalidated. To be clear, I actually am very supportive of the other portion of the bill that requires additional reporting. I do have concerns about the lobbying advertisement portion of the bill from just more of a constitutional standpoint.
Okay, I'll move on to SB 752. This is a comprehensive bill revising requirements related to campaign advertisement disclosures. Among other things, the bill would reduce the top contributor threshold for non-statewide candidates and candidates for the Board of Equalization from $50,000 to $10,000. The bill would alter disclosure wording and formatting in several places, and the bill would also include a change recommended by Commission staff. This change would narrow an existing exception that allows a committee to omit disclosures on individual ads posted on social media if the committee includes certain disclosures on its landing page or its cover or header photo. The bill would narrow the exception to apply only if the ad was posted by the committee that paid for the ad. And this gets at the issue of ads paid for by the committee but posted by third parties. The bill is sponsored by the California Clean Money Campaign, and 14 other organizations are listed in support. SEIU called into the hearing to oppose the bill. Their main concern was that they believe the changes in the bill impose additional and unnecessary burdens, particularly because the disclaimer requirements have been revised multiple times over the years since the Disclose Act was first passed. I won't go over all the detailed changes made by the bill. There's a lot of them, but I'd be happy to take any other questions on the bill.
Thank you, Ms. Takano. Commissioner Baker?
No question.
All right.
Thank you. And that's all I had for today. Happy to take any other questions.
All right. Any other questions for Ms. Nakano on her ledge report? All right. Any public comment on item 3, the legislative update? Hearing and seeing none. Thank you, Ms. Nakano. We will see you next week.
Thank you.
All right. We'll now proceed to item number 4. This is a combined item on our agenda. It is both a discussion and interested persons meeting on 3 proposed regulations related to behested payment reporting. And so, for the benefit of the public, we are going to first proceed with the interested persons portion of item number 4. And this is an opportunity for any member of the public, any stakeholders to voice any questions, concerns, commentary that they have about the proposed regulations. And for purposes of our interested persons meeting, there are no time limits on public comment. So at this time, we will go ahead and open up the phone line for our interested persons comment period. Do we have anybody who wishes to provide comments during the interested persons portion of item number 4?
Yes, Chair Manich, this is Emily Andrews with Olson Remshow on behalf of the CPAA Regulatory Committee.
Morning, Ms. Andrews.
Good morning. I am basically, the CPAA Regulatory Committee has met briefly to review the proposed regulations. And at this time, we're not necessarily prepared to provide substantive comments on the draft language. I think we're still kind of reviewing in detail what the language is and kind of what the impacts are on the existing requirements. So at this time, really what we wanted to say is that we are reviewing the language. We appreciate it being put together, and that we do intend to provide some substantive comments, but sort of given the level of change here and, the need to really review that in detail, in the couple of days since the language has been released, we've not had an opportunity to really substantively put together our comments at this time, but we do expect to have some feedback, and certainly will be providing that to staff or to the commission as soon as we're able to. So nothing substantive to provide here, but we did just want to flag that we are looking at it and do appreciate the opportunity to work on potential issues that we identify in our review.
Great. Thank you, Ms. Andrews. Can I ask just one question? You note that, I would just note that this is up for a pre-notice discussion next week at our commission meeting. Does CPAA believe that they would be able to have any even preliminary comments for the benefit of the commission by next week's meeting?
I'm not 100% sure about that, Chair Manich. I think we can certainly try to get together and have maybe preliminary comments for that meeting. I think it may be a little difficult. We are in basically a reporting month here, so a lot of the folks that are normally spending time reviewing this are a little bit tied up, and I think the expectation is that folks would have more time to dedicate at the beginning of August. So I'm not 100% sure that we'll have comments, but I can certainly circle back with our committee and see if we're able to at least kind of get together maybe some preliminary thoughts that we could share at next week's meeting.
Great. Thank you. Appreciate that, Ms. Andrews. Do we have any additional public comment during the interested persons portion of item number 4? Hearing none, we'll go ahead and conclude the interested persons portion of item number 4 and proceed with our committee discussion of the proposed amendments in item number 4. I had one question for staff, and Mr. Bainbridge, are you staffing this one alone today?
Yeah, our behested payments guru is on vacation. Karen Harrison's on a much-deserved vacation, like a lot of people this time of year, so I'm substitute teaching for her today. She'll be back next week, so save the real difficult questions for the pre-notice commission meeting. All right, I'll do my best.
So my question for you, it's more of a technical edit, and that is to 18424. I'm looking at lines 16 through 17. This is where we define the term proceeding for purposes of this regulation. And my sense is that the spirit and intent of this is to narrowly define proceeding and not include legislation as a proceeding for purposes of that. And I'm supportive of that interpretation of it. I wonder, though, the way it is currently written, it says a proceeding for purposes of subdivision B includes, which, when you say includes, it suggests that there could be other things not included on that list. So either I would suggest that we have a specific provision under B that makes it clear that legislation is not included within the definition of proceeding, or if there's a way to amend B1 to make that clear in the existing language, I'm open to that. But either way, I think that is something that we should clarify.
Okay, and I would probably lean towards specifically stating it doesn't include legislation, because proceedings can take different forms and be called different things at different levels. So this language is borrowed from the conflict of interest rules, which is where it came from, and we have experienced where something comes in and they don't call it any of these things, but essentially is. So if that's the direction, I think the better way to go would be to specifically exclude legislation rather than trying to capture everything that could possibly apply.
Okay, and that's fine. Commissioner Baker, did you have any questions on this?
I do. Thank you. One is a sort of background fundamental process question, and I have some policy questions that will continue to inform the discussion about this, and maybe for those attorneys out there who are in the reporting area, kind of give them some suggestions. The process question is, do we have the authority, does this commission have the authority to prohibit certain behest payments? Because we are really in the realm of how can we make them more transparent and more substantive information so the public has information about it. And I'm thinking of the scenario where an official, some of the scenarios that you outlined in the memo, official controls the nonprofit and controls the expenditures of the funds, or maybe was a founding member or their family member retains a salary. Do we have the authority, if we wanted to actually prohibit those type of behest payments in those circumstances?
I don't believe there's anything in the statute that gives us the authority to prohibit behested payments. Okay. I think we're, again, in the realm of disclosure and reporting, and what that looks like is our main area where we can regulate. Okay.
So the legislature would have to act if they felt that a scenario where, again, an official, spouse, or the official themselves retains some benefit or control from a nonprofit, if they determine that it is not a good thing, it doesn't look good, even if it's most innocent, that we don't have, beyond transparency and disclosure, we don't have the authority to do it. That's what I'm hearing. Okay. Yep. Because I think that's important to lay out at the beginning. For my part, was to understand what we can and cannot do under current law that's on the books. Okay. In my policy questions are kind of triggered by the memo, so I think I'll throw out a couple of them for consideration. In this scenario where we are looking at, and it's on page 5 of the memo, and it goes to the proposed reg 18424. the family members. We're defining immediate family members as a spouse or dependent children. And there are some scenarios that have been in reporting where an official's staff is on the nonprofit, or so somebody who works for the official but is not a sibling or a immediate family member. I'd like us to look into that if we think it's appropriate to try to capture that scenario of where you put your staff on the nonprofit, and maybe that individual works for you. And it triggered a question for me about what if the connection with the nonprofit develops after the behest payment. So somebody, I'm thinking of an official who is asking for contributions to go to a nonprofit. They go to the nonprofit, and then later, like maybe within 12 months, a family member ends up becoming the CEO of that nonprofit. That may be totally fine, but I asked myself that question as I was looking at the regulations. Is that something that we have a concern about? And I do. It goes to another question, and we are looking back 12 months past. So in our reporting, if you're looking at the top of page 6 of your memo, and most of what the regulations are saying is that if there's the relevant time period is going to be if there was some kind of contribution or, proceeding 12 months back. Well, I'm thinking of the scenario where an official behests a payment from someone, and then within the prior 12 months, they get a no-bid contract, or they get a bid contract. But what happens after the behest payment is paid, as opposed to 12 months before? And maybe I'm misunderstanding what the timing is of the proceeding and the 12 months, but that came to mind as well. Am I getting that one right?
Well, I think I'm following what you're saying. Okay. I think we currently in the regs have a look-back period that's 12 months.
Yes.
You're suggesting that, what about the other side, where 12 months following the behested payment, yes, some type of action occurs? And I would say the only, I have some concerns about trying to regulate that, and the main one is, bear in mind that these reports are supposed to be filed within 30 days of the behested payment being received. Mm-hmm. And so in order to capture that subsequent activity, you'd have to continue tracking that relationship, and presumably, I guess you would file an amended report at some point, and that seems burdensome,
yes,
to say the least.
Yeah, I can see that.
So that would be my concern there.
Yes, and I'm trying to capture the scenarios where, again, an official asks for a benefit from the nonprofit, and then the nonprofit gives or from a donor to a nonprofit, and gives very generously, and then there's a benefit that happens after the fact. I can see how that would be difficult to track and how you do that, but I want to highlight the issue because it's part of what I'm thinking about as we're looking at all these points. Additionally, going to, and I may be jumping ahead too much. I'm getting to where the official is appearing as a guest speaker. Maybe I'm jumping ahead to another regulation, but if this is fair game now, I'm going for it. I'm imagining a scenario where a guest speaker is the official, and at the event, the official says, and please give generously tonight. I'm the guest speaker at something, and I talk about, well, the FPPC isn't actually bound by behest payment rules, I've learned, but let's say we are, and I go and I speak and I talk about the FPPC, and then I say, and by the way, please give very generously to this organization. Now, I think it needs to be clear upon the official, they have changed the fact pattern, and they have engaged on the spot, even though maybe they were just going to be a guest speaker before and they weren't featured prominently in the invitation. I don't know that we need to do that. I don't even know that we have to change the regulation language to cover that scenario. Maybe it's something in our education process, but that's important to remember as well. I've been at places where I've seen people do that and not realize they've triggered a behest payment obligation.
Yeah, I think that's a good point to make, that this regulation, if a request is made that would qualify as a behest on its own. So in your scenario, the person says, and give to this organization, a behest has taken place there. We don't even need to get to this regulation. This regulation captures a situation where a behest isn't expressly made. It's when does the solicitation combined with someone being featured in the solicitation becomes a behest. But if there's just a out-and-out behest made at a meeting, that in and of itself, we don't even need to look at the reg, that under the statute becomes a behest.
It's important that this regulation with respect to being a featured speaker on an or not too terribly featured speaker on an invitation, that doesn't give you carte blanche to then go to the event and have at it without triggering some other obligations. Okay. And the other scenario I was also trying to sort of see how this plays out is when there's a caucus that an official controls the funds for. And, you know, whether it's, for example, the Legislative Women's Caucus, which I was a member of, if they were having an event and they want to have contributions, they're funded by the same folks who give to campaigns and to expenditure committees. And how these rules may apply in that scenario where the legislators are controlling that caucus. I believe the answer is if more than half of the members of the of making the behest, well, I'm getting this wrong, more than half of the members of the nonprofit are officials, it can trigger the behest payment rules. I just want to make sure we're not creating a scenario or changing the rules with respect to the reporting requirements of legislators who set up a nonprofit caucus, maybe it's the tech caucus or whatever, and they somehow are have an ability to skirt the rules on behest payments.
Yeah, I think that's a similar issue where if there's a caucus, this rule of the majority listed is to get at whether someone is being featured. Now, if the official is involved in the organization and has made a behest, as that term is defined elsewhere, we, again, don't need to get to this regulation about whether they're being featured, and we don't have to count the number of people that are on the board and see if it's a majority. You're still going to have a behest. That just comes up in the situation where the official hasn't made a behest directly, but they've been involved with the fundraising solicitation and they're featured in some way on the solicitation.
And presumably if one official creates a nonprofit that they solely control, and it's almost an extra source of funds or influence on the legislator as well as on the people who are giving the money, that's going to need to be disclosed under what we're talking about because they receive a direct benefit and control. They control it.
So you're saying in the enhanced disclosure portion of this, right? Okay, so we wanted the other regulation.
Going back to the other end, sorry. Moving quickly.
Right, yes, as drafted, they would have whatever their role would be. It looks like if they're controlling it, then they would need to disclose that they control it.
Because, you know, the scenarios that I think have made the public and have been reported, and I think rightly so, are where an official sets up and controls something and it looks like it may be an extra way to get, I'm not saying they're doing this, but it can create an opportunity, even if not intended, to get around campaign contribution limits or funds that you get to control, and the scenarios where, as I mentioned before, where you can give a benefit to someone after the 12-month period. Those are the ones that are kind of lighting up in my mind of concern. And I want to make sure that we are keeping the feet to the fire on those, and these regulations either enhancing that or certainly not weakening it. And those are my questions. Thanks for taking those comments.
All right. Well, I would just say, I think, I just want to compliment staff, and particularly Ms. Harrison, who I know has been working very hard on this. I think the reg package, to my mind, is very well done at this point. A couple minor tweaks, we mentioned a few today, but I think, you know, the goal of improving transparency with behested payments, I think, is front and center in this reg package. I think we're going in the right direction there. And I think also it is balanced by the fact that we recognize that under the existing statute, it can be difficult for public officials to get the information they need to comply with the law. And so the reg that allows estimated payments, I think, balances that out quite nicely, and clarifying the charitable organization fundraising solicitations rule, I think, is also very helpful. So in toto, I think staff has done an incredible job with this, and so I look forward to continuing our discussion, receiving some hopefully substantive feedback from members of the regulated community.
Agree. Great analysis and work and feedback on this has been very helpful. Thank you.
So, and just to sort of close it out, there's one additional area that my understanding that staff's going to be reporting on and that's the donor-advised funds and how that relates with the existing term payor in the statute. And so, Mr. Bainbridge, I think that's coming to us next week, the full commission meeting, right?
Yeah, that's right. As part of, or I guess prior to the pre-notice discussion of these regulations, we're going to have a couple presenters who work in the nonprofit world and are familiar with the donor-advised funds that are going to give a presentation about how they work and provide some information from that side of things on how this all fits together and how they see some of these reporting requirements.
Great. Well, look forward to that. All right. Any final public comment on item 4 before we continue on our agenda? Hearing and seeing none, we'll proceed to item number 5. Discussion of items for our August committee meeting. I would anticipate, of course, we're going to have a legislative update from Ms. Nakano. Mr. Bainbridge, can you remind me, did we already schedule anything for the August LNP meeting?
Not that I recall at this moment.
Okay, well, I couldn't recall it either, so. Commissioner Baker, is there anything specific you'd like to hear back on next month?
I don't know that this needs to go in August because I think the legislative calendar is not done. Of course, we won't know until the middle of October what bills not only have been passed, but which ones are signed into law. But I would like to present this idea for the appropriate meeting in the fall where we talk about potential legislative package that we may take on in the future. And one is if we want to suggest either sponsor or suggest to the legislature that they prohibit prohibit this scenario where a behested contribution can be given to a nonprofit that an official controls or receives a financial benefit from because their spouse works there. I think I would like to have that conversation. And if we want to draft and sponsor legislation on that ourselves, as well as in that meeting when it happens. Again, it's my first year going through that process, but I imagine it is a September, October meeting. If the recurring contribution bill doesn't get signed, that we may either be taking regulatory action or on a dual path wish to sponsor legislation next year on it. Because as you've seen today, there are ones that are very important for transparency and confidence in our process, and I think we can play a role in that.
Excellent. All right. Anything further before we adjourn? All right, I will move to adjourn.
Second.
Mr. Vogt.
Commissioner Baker?
Aye.
Chair Matich?
Aye. All right, thank you, everyone.